This story now, President Ramaphosa failed to make the case why he thought approaching the Constitutional Court directly was within its exclusive jurisdiction. This is why the Apex Court threw out his application to declare unlawful and set aside the Section 189 panel report. It had recommended Ramaphosa as a case to answer to for possibly committing violations of the Constitution and the law in the Phala Phala scandal. But when a vote on the matter was taken in Parliament, the Good Party abstained in order to wait for the outcome of the court processes. Let's discuss this now with Good Party Secretary General Brett Herron. Brett, good morning and thank you very much for your time. You know, just immediately after that judgment, Good Party's proposal of a third way came to mind. You had proposed proceeding in principle with the Section 89, but delaying the commencement of the impeachment committee's work to after the Court had dealt with the president's application. It's since been dismissed. Your views?
Well, I think obviously our position was the most sensible position because what happened on the 13th of December was that Parliament effectively voted not to accept the recommendations of the independent panel. So to some extent, the President's application to review and set aside those findings are moot because that report has been rejected by Parliament with that vote. If Parliament had accepted our proposal, which is that the report, the recommendations, well, there was no basis to reject the recommendations, but that the President did have a right to approach the court to review and set aside the findings of the independent panel, and that any work of a Section 89 inquiry should be paused while that happened. Mm-hmm. But Parliament has effectively rejected the independent panel's report, and the Constitutional Court's finding yesterday doesn't really take the matter any further. It doesn't assist either party because Parliament has decided on the report.
Mm-hmm. But also, of course, we know that the court didn't deal with the merits of the case. It was purely jurisdiction. However, we do know now that several parties have come out saying Parliament needs to set up an ad hoc committee to look into the Phala Phala matter. Just your take on that, because there should essentially be no movement if the merits haven't been dealt with. But there's just this impetus now to say, no, let's get on with that ad hoc committee.
Well, I think that, there was a recommendation from an independent panel that was presented to Parliament, and Parliament rejected it. I don't see that there's any basis for coming back and saying, well, now that the Constitutional Court did not entertain the direct access application, that there should be a committee should be established, because, as I say, the Parliament has effectively found that the recommendations did not warrant any further inquiry. That was the question that was put to Parliament on the 13th of December. Of course, as you said, the Constitutional Court did not deal with the President's review application and the grounds for it. And the President was essentially sent back to the High Court to start there. And he may or may not do so. If it was me, I would do so. But as I say, the Parliament has rejected the report, and there seems to be no basis for proposing an ad hoc committee when the report has no standing.
Mm-hmm. But this sort of puts you in limbo. But there's also a broader conversation now about political parties not being allowed to arbitrarily use their majority to stop processes of holding leaders accountable. Because as Parliament, you're still none the wiser as to what exactly happened on the farm and whether the President conducted that process of reporting the case properly. So if you're saying there's no basis for the ad hoc committee, but also you're not sure as members of Parliament if the President would pursue it any further, does that mean, at least as Good Party, you're saying it's a done deal now?
Well, it's not a done deal in the greater context, because the Hawks are investigating. This thing started with Arthur Fraser making an affidavit and lodging it with the Hawks for investigation. And various other authorities are investigating various aspects of the allegations, including the Reserve Bank and SARS. So they are investigating the Public Protector. There are lots of investigations going on, which could bring the matter back to Parliament if there's an adverse finding, say, by the Public Protector. That certainly could bring it back to Parliament. But to proceed to establish a committee to interrogate the recommendations of a report that has been rejected by Parliament doesn't seem to be a lawful or common sense way to proceed. And that was exactly what we were arguing on the 13th of December. The binary choice of yes or no was not a vote that had any foresight, because really, if you looked further down the line, you would have seen that we could end up being in this position where Parliament has rejected the report and its recommendations, and the courts have not yet set aside the report and recommendations, and so those allegations are very much alive. But Parliament has already rejected those findings.
So basically what you're saying is that it was probably political miscalculation on some political parties' front, because perhaps they wanted to tie it in with what was happening within the ANC insofar as their conference was concerned, that whatever outcome would have come out of Parliament perhaps at that time would impact what happens at the conference. Do you think perhaps there was just that miscalculation that some were not willing to wait?
Absolutely, and I think that's exactly what it was about. For both the yes and the no's. It was an opportunity, and the opportunities were grabbed. So those who were grandstanding for yes, the report should continue, were playing a very dangerous game with the integrity of the South African democracy, because they were doing so for party political purposes. And of course, the ANC was closing ranks around the president and protecting him. And they were whipped to do so. There were 4 or 5 members of their caucus who did vote yes, that the recommendation should be adopted and the Section 89 process should proceed. But ultimately, the most sensible solution or proposal in the room was the Good Party's proposal, and it was rejected. So that's very unfortunate, because it does place us in this strange place where pure party politics on both sides of the aisle have put us in a position where Parliament can't now interrogate that report.
Indeed, a very strange place and unfamiliar. Brett, thank you very much for your time this morning. That was Good Party's Brett Herron.